Moving to Florida certainly has its advantages. Hi, I'm Craig Hirsch. Whether you're here for the great weather, the beaches, to boat, golf, play tennis, or just enjoy an active lifestyle, you're just like thousands of people who move to Florida every year. Better yet, Floridians don't pay any state income tax, inheritance tax, or intangible tax. Special homestead laws limit increases to the assessed value of our homes for property tax purposes and serve to protect our homes from the claims of certain creditors. Thank you for joining us, because in this video we're going to examine the estate planning, homestead, tax, and other legal questions common to new Florida residents.
Can I save taxes if I become a Florida resident?
Generally speaking, the answer to that question is yes. Hi, I'm Michael Hill. Since Florida has no state income tax, most people save taxes when they become Florida residents. While earned income in another state will most likely continue to be taxed in that state, you may save a considerable amount of taxes on your investment income, and the homestead exemption and Save Our Homes property tax cap might mean savings of thousands of dollars in property taxes each year. While there's no bright line test for becoming a Florida resident, a variety of factors are usually considered. Among other things, you should have a Florida voter's registration card and Florida driver's license, declare a declaration of domicile, and declare homestead status on your Florida residence. We can help you review the facts of your individual situation to determine whether Florida residency is advantageous for you.
What do I need to know about Florida homestead laws?
Florida residents should declare their primary residence as their homestead. As Mike just mentioned, you can save thousands and thousands of dollars annually on property taxes with the Save Our Homes property tax amendment. Moreover, Florida law serves to protect our homes from the claims of certain creditors both during our life as well as at our death when we leave our homes to our loved ones. Florida homestead, though, is quite different than other properties or residences. Florida has very strict descent and devise rules, meaning that if you don't leave your homestead to the right person, or even in the right manner, then you might have an invalid devise. You might be surprised to learn that a standard credit shelter marital trust provision is actually an invalid devise under Florida law. That's why it's extremely important that you come in to update your estate plan when you become a Florida resident and you own Florida homestead.
Is my will or trust from up north still valid?
So long as your will or trust documents were properly established in your former home state, chances are they are still valid, but you really shouldn't leave it at that. Craig just gave an example explaining how a valid trust may nevertheless have invalid provisions now that you've become a Florida resident. The homestead issue is just one of many examples why your documents may require updating. Most state laws are different from each other, including Florida's, and just like the homestead issue, these differences could result in unintended and adverse legal or tax consequences if you don't update your documents. Not only are will and trust laws different, but so are the laws governing powers of attorney, healthcare surrogates, and living wills.
My attorney up north said I'm all set, that my will's just fine.
Unfortunately, there are too many times when that advice just isn't proper. To make sure you're not confused by conflicting advice, we're happy to put your northern attorney on the speakerphone during your initial consultation with us. We value a team approach and can work together with your northern attorney to achieve the best result for you. In fact, we're happy to include any of your advisors, such as your CPA and financial advisors, during the planning process. We'll talk more about this a little later in the video.